Constitution shall stand amended in accordance with the terms of the bill. To restate the position, Article 368 deals with the amendment of the Constitution. The article contains both the power and the procedure for amending the Constitution. No undue importance should be attached to the marginal note which says procedure for amendment of the Constitution. Marginal note plays a very little part in the construction of a statutory provision. It should have much less importance in construing a constitutional provision. So, Mullahs, when your lordships talk about temporary, Mullahs, really you have to look at the Constitution. Because it had to be temporary in 1950. There was no element of permanency. It could not have been. And this is the marginal note. Give it to my lord. Do you have copies?
This is a marginal note. There's no question about it. It is a marginal note.
Yes. So, Mullahs, you can't be saying, which is what your lordships are concerned with, but it was temporary. But that's only when you look at the marginal note. It had to be temporary because there was no other way to deal with it. You couldn't have said it is permanent.
There's no doubt still about the fact that this forms a part of Part 21 of the Constitution, which still deals with temporary and special provisions.
I'm not disputing that. These are all different provisions, Mullahs.
They've all been clubbed together in Part 21.
That's correct. But we looked at it in the context of, Mullahs, what was going to happen in the northeastern regions. Gujarat and Maharashtra together, what was to happen there. Issues of Marathwada. So those councils had to be created, boards had to be created. That's why they were temporary. Telangana, that's why they were temporary. Not for any other reason. And that's why this was also temporary. It's the same logic. But the fact that it is temporary doesn't mean that the article is temporary for all time to come. You can't interpret the marginal note in that fashion. So the language of 368 to our mind is, I'm sorry.
317. It is actually good.
If you look at the heading, Mullahs, it says temporary and transitional provisions. So 2 is temporary and 2 is transitional and 3 is temporary.
It's 368 power, right?
In this case, no, 356 power. No, it's 356 because they converted. What happened? Well, let me just, in one sentence, they say, in one sentence, I'll tell you what they did. They converted the Legislative Assembly into the Constituent Assembly. Right? Right, dissolved. They converted it into a Constituent Assembly. Then they said that now Parliament, because of 356, Parliament is exercising that power. So the Parliament is the legislature. And because it's a Constituent Assembly, Parliament of India is the Constituent Assembly, and therefore we can do what we do. That's in one sentence what they did. And they recommended to themselves. So instead of clapping by 2 hands, they clapped by 1 hand. Because they exercised the power of the legislature themselves. And because the legislature's consent was necessary to give that consent to themselves, and abrogated 370. Unique, constitutionally a unique, unheard of. I will not use that expression. A procedure that is unknown to law. Because the objective was entirely different. And I've been saying that from day one.
That's how they brought in the
10 minutes. later. Exercise the power. Yes. Seven is a different issue. It's on the definition. I don't think so. Discuss that. Discuss it.
To apply the proviso to clause 3 of Article 370.
Yes, yeah, because they understood it that way, that it required the previous.
And then what they do is they say that the Parliament exercising the powers of the Constituent Assembly
Yes,
by virtue of the fact that the Legislative Assembly has been dissolved.
yeah,
Assuming that the Legislative Assembly was not dissolved, that could have exercised the power of the Constituent Assembly.
that's right.
Now that it has been dissolved,
Yes,
under 356, Parliament has the power to make laws with all aspects of whether it's
Correct.
list 1, list 2, or list 3. And then they exercise the power under the proviso.
that's right. That's right. So, Malad, actually, they understood 370 sub-article 3 in the manner in which I am, Malad, stating before your lordship. It is their understanding right till the end. They don't understand. Which is why I wanted to bring it at this stage, Malad, so that now your lordship knows, Malad, the larger picture, so to say. So we are going into interpretation of 370 sub-article 3, which they themselves accept, that the proviso applies. No, talk about.
We'll come back after lunch. Mr. Sibbal, if you can just in a very brief while, take us through the process which was followed. We can go straight to that. Now we've understood anything more in Keshwananda apart from these four judgments? All right, we'll see that and then so that we come to the end of then reading Keshwananda.
Yeah, 25th November.
Yeah, if you Lordship sees the facts, I think it will help. No
Where he said we enter a life of contradictions. That's how he
That's
last.
It's about his amending powers also. in
That's
that.
right, he covers it. He covers it.
It was criticized on both the sides.
That's right.
It's too liberal and too rigid.
Obliged. Deeply obliged.